Hi, folks. I'm so thrilled to introduce you to TrustArc's Privacy PowerUp series. Our first segment of the series is focused on getting started in privacy. Whether you're a compliance pro, a lawyer, still in school, and interested in privacy, or just stumbling upon this video, we've got you covered. In the next 15 minutes, we'll go through some key concepts and essentials to know about when managing or supporting a privacy program. I'm Val Ilchenko, General Counsel and Chief Privacy Officer at TrustArc. Let's get into it. Let's start from the beginning. What exactly is data privacy? This is a bit of an oversimplification, but data privacy is really the responsible and ethical handling of data, particularly focused on information that is considered personal, identified, or identifiable to a person or a household, including how, where, and with whom it's collected, stored, managed, and shared. Like Uncle Ben said in countless Spider-Man reboots, with great power comes great responsibility. Supporting a privacy program means being the guardian or responsible steward of folks' personal data, making sure it's safe from prying eyes and used appropriately. So why is data privacy important? Just for illustrative purposes, let's walk through a parallel scenario. If you have a pet or you know somebody who does, if you or they were to bring that pet, say a dog, to doggy daycare, what would be reasonable to expect? Is it reasonable that they take care of and keep the dog safe? Absolutely. Perhaps they use a security camera and pet camera to monitor the premises and the pet for safety? Sure. Do they have books and records on when the pet arrives and leaves, billing records, etc.? Sure. But can they clone your pet, sell your pet to somebody else, take photos and sell them on the internet? Absolutely not. Those aren't really reasonable things, and I could come up with countless examples, but the reality is that the premise is the same. Everyone deserves a right to privacy in numerous aspects of their physical and digital lives, as do your pets, of course. And much like you don't expect your dog to get cloned, you expect that you have privacy in, say, your own home. Now that we've gotten an illustration out of the way, let's get more practical. Privacy management is important for your clients for a number of reasons, including the following. Privacy, for example, is a societal expectation now. You can't open up a major news or tech publication like Wall Street Journal, Forbes, Gizmodo, you name it, without seeing privacy news frequently, let alone seeing a billboard for the iPhone, for example, while you're driving over the highway. Next is trust. Trust is a critical customer and buyer expectation and likely a competitive differentiator for your organization. Protecting your clients' data, which can mean their data, their employees, their users, etc., builds and maintains trust, which translates to loyalty, satisfaction, and confidence in your client's ability to do good. The third reason or area is compliance. Yes, following the law is important. Not following the law can have lots of pretty serious ramifications, ranging from reputational and brand harm to legal risk, like a lawsuit, to potential for hefty fines. Remember that laws like GDPR have fines up to 4% of worldwide revenue for severe violations. And similarly, for certain high-risk activities, the EU AI Act will have fines up to 6% of revenue, which is huge. Next is risk management. The consequences are beyond just the typical meeting the law considerations and include things like data breaches, improper data use, etc., which can have vast consequences such as financial, time loss, reputational harm, loss of business, etc. At a minimum, these can be seriously disruptive to your organization's operations. At worst, they can create an existential threat to your business. And next is ethical responsibility. While not per se a business reason, ethical responsibility is critical to the prolonged health of your business and how it's perceived by the public and its clients. Ethical responsibility as a concept is very much aligned with a hearts and minds type advocacy approach for privacy program management. You have a responsibility to protect and safeguard information maintained by your organization, do others as you'd like done unto you and all. Now on to some key data protection regulations and common frameworks. If you're just getting started, you'll want to know about some key benchmark laws and some common frameworks or standards. I'll outline some of the many examples for a good starting point. The EU's comprehensive modern privacy law, known as the GDPR, or General Data Protection Regulation, was a really watershed moment for privacy and changed the global landscape dramatically. Consider looking at Articles 1 through 6 in particular to start. These articles establish the objectives, principles, and legal basis for the regulation, as well as include some key definitions. Next is California's Privacy Act, known as the CCPA, or California Consumer Privacy Act. CCPA was a similar watershed moment in the United States. While hailing from California, CCPA really did change the US landscape and resulted in a string of other US laws that have similar principles and values. CCPA has many similarities to GDPR, but also has some key differences, including the concept of a sale, or with the introduction of the CPRA, the California Privacy Rights Act, itself an evolution, the principle of sharing of data. And these are defined terms that I recommend you look up in the definition section. Next is HIPAA, or the Health Insurance Portability and Accountability Act in the US. You're likely familiar with having to sign a document prior to seeking medical services in the United States. This action is one of the many prescribed by HIPAA. HIPAA addresses the safe, secure, and ethical handling of protected health information, or PHI. HIPAA has been a pioneering privacy law and precedes the GDPR and CCPA by more than 25 years. Next up in Latin America is Brazil's Privacy Act, known as the LGPD, which carries many similarities to GDPR but brings modern privacy protections to a large geography within Latin America. Next is China's Privacy Act, known as PIPL, or the Personal Information Protection Law. PIPL has similar protections to GDPR, but its enforcement may carry criminal sanctions for violations. Aside from the regulations mentioned, there are also some frameworks or standards that could be a great starting point, such as the NIMITY Privacy Management Accountability Framework, the OECD, or Organization for Economic Cooperation and Development Privacy Framework, the APEC, or Asia Pacific Economic Cooperation Privacy Principles, as well as the NIST, or National Institute of Standards and Technology, and ISO 27701 principles. Next, let's talk about the 7 core privacy principles that you'll often see addressed in these privacy laws and frameworks, leveraged by organizations, and a good North Star. The first principle is lawfulness, fairness, and transparency, which is all about being upfront, being honest, and not hiding the ball. This can be done in part by clearly explaining how you handle data and only collecting it under a lawful basis or intent, for example, under consent or performance of a contract. Next is the second principle, which is purpose limitation, which means you should only collect data for a specific, legitimate, and the original purpose for which you needed it, or a compatible purpose. Third is data minimization, which means you should only collect what is needed to fulfill the current obligation or purpose and not collect data, quote unquote, just because or in case you need it later. For example, if you needed to look up a word in a dictionary, you wouldn't normally buy 10 dictionaries. Similarly, if you order 2 pizzas, you wouldn't normally ask for 10 pizza boxes. Similarly, don't overcollect data you don't need. The fourth principle is accuracy, which is really about keeping data up to date. This is a bit nuanced. Sometimes keeping it up to date means letting your clients inform you of changes. Other times it means keeping track of it yourself to make sure that you don't have incorrect info. The fifth principle is storage limitation. Once you've collected the information lawfully, fairly, and transparently, of course, make sure not to keep it longer than either agreed upon, disclosed, or reasonable under the law. Some people might call this a data retention schedule or data retention period where you just don't keep data beyond a certain point. This is really going to be context dependent. Next is the principle of integrity and confidentiality, which is designed to address how an org secures and protects data, making sure it is not accessed, destroyed, or modified without authorization. Imagine a bank vault, thick steel walls, etc. Now imagine the digital version. That's really what integrity and confidentiality is meant to address. And finally, the seventh principle is accountability, which is designed to be a bit of a catch-all. You should be prepared to do things in a documented or demonstrable manner. Showing your work and being ready to is an important facet of these programs. Accountability means being able to prove it, and while technically not a core principle, I'll augment by adding, make sure it's not a one-off result, but a sustained, repeatable, and demonstrable one. Remember, these are just some considerations, not a full list. Next is building a privacy program. Building a privacy program can feel daunting. Here are a few considerations and activities to consider to get started. A great starting point is to identify key contacts and build relationships. Know the players, know who can help you find answers, etc. Solve problems and find the right people. Building relationships is key. And in a SaaS company, for example, that might mean folks like engineering, product, HR, marketing, etc. Remember that these, many times attorneys, privacy pros, etc., aren't the ones who are actually implementing a, let's say, data subject access process. You might be dictating what is needed. You might be working with those folks, but somebody else might have to add new code to a product or build out processes with you. Next, it's helpful to assess current practices. Choose a North Star type framework, a key privacy law, or a series of laws, and establish what you think are your baseline requirements. Now assess what your organization has against those requirements. In other words, conduct a gap analysis. Once you have a gap analysis, create an implementation plan and focus on the areas of highest risk first. This implementation plan should effectively result in a set of controls and standards which can be used to build an overarching controls framework or privacy requirements across an organization. As part of assessing your practices, disclosures, policies, and procedures need to be crafted. Making things like privacy notices, or for those who needed a data processing addendum, can be supremely helpful, because through the process of creation of these documents, you'll effectively be creating an assessment or gap identification process. For example, if you disclose something in a privacy notice that's typically required under numerous laws, like how to have your data deleted, you'll likely realize, okay, well, for me to disclose this in a policy, I really need to make sure that we do it. And so that's just a helpful vehicle, not only to create useful disclosures you need by law, but to realize what else may need to be chased down through your programs. Next, and this is a bit less tactical, but it's still important, which is instilling a privacy-first culture to successfully achieve your priorities and goals, including building a training and awareness program. You can't be everywhere, and privacy is a team sport. Building things like mandatory annual awareness trainings, conducting internal hearts and minds campaigns to get buy-in, and giving function-specific trainings are really useful ways to get buy-in across the organization. Shifting an organization which by and large is focused on things other than privacy to one that is also focused on privacy requires thoughtfully injecting privacy and awareness into its DNA. Start with some basics, like just getting folks up to speed on what is the definition of personal data, or what are some key principles like data minimization or a storage limitation that you want everybody to be aware of, as well as to when to sort of pick up the bat phone and call your privacy team. Next is continuously monitoring and reinforcing these requirements. Privacy is a journey, not a destination. These programs will evolve as the laws change, and controls need to be regularly checked, for example, annually, to make sure things remain as required. Next up is individual rights and data subject requests. Some common rights include the right to know or access, where individuals can ask to see or understand what data is held about them. Next is the right to rectification, where individuals should be able to ask for and receive corrections if they find or see inaccurate or incomplete data, like a misspelled name or wrong address. Followed by the right to erasure, also known as the right to be forgotten, which became legendary after the 2014 Spain case about a popular search engine's results. This is really about the person's right to request deletion or removal or some or all of their information about them. And next is the right to restrict processing, where individuals can request to limit or preclude certain types of data processing by an organization, kind of like putting a do not disturb sign on their info. As well as the right to data portability. This is basically the right to get your data in a common or machine readable format. Think Microsoft Word or Excel or Google Docs. This is so folks can either keep a local copy of their data, or should they choose, move to a new company or service and import their prior data over. And finally, the right to object, such as opting out of cookies or receiving emails. This allows folks to object to data processing in certain cases, for example, by opting out. The above aren't absolute and may vary by jurisdiction or geography, but are a good starting point to consider. To learn more about individual rights, watch Privacy PowerUp Video 4, which is dedicated to this topic. Next up is incident response or breach response. While headlines use the term data breach, incident response is probably the better term and skill to have with respect to privacy program management. To start, not every incident is a breach, and incident response can happen quite frequently depending on where you work. First off, this is a huge topic and not solely related to privacy at all, but I will attempt to highlight some considerations from a privacy perspective. First, an incident may have roots in a security event, or it may be a purely privacy-related event. In either case, understand what the cause of the incident was, what information was affected, and to whom such information belongs and what it pertains to. While doing so, refrain from broadcasting to outside a predetermined group of folks, and certainly refrain from public disclosures at this time. Second, understand the potential harm that could be caused by this damage, e.g., could it result in confidential data being exposed, financial information being exposed and creating risks of theft or fraud, and so on. I sometimes call this as potential blast radius. Third, understand if this risk is ongoing, imminent, or now contained, meaning whatever open window of risk has or can be closed has it. If you have not contained some kind of ongoing threat or incident, this work needs to absolutely continue until containment occurs. Fourth, understand your obligations pertaining to this data if the worst case does happen, e.g. the data is exposed, exfiltrated, destroyed, manipulated, etc. Obligations vary by jurisdiction. For example, every state in the US has separate obligations, and there are different obligations in Europe and other parts of the world as well. Fifth, generally, you'll want to escalate this internally and possibly to your outside counsel, insurance brokers, etc. At this stage, you will need to consider if law enforcement or government agencies need to be informed, but absolutely consult counsel here. For example, if this appears linked to criminal activity such as an intentional malicious breach, you might need to have outside parties involved that I mentioned. Sixth, if it's determined that a notifiable event has occurred, you will want to assess who needs to be notified and how to properly notify. This may range from notifying clients, affected individuals, regulators, the public at large, etc. Seventh, you'll want to figure out what other post-incident activities may need to be done, either due to contractual or legal commitments or public expectations, etc., such as call center operations, credit monitoring, and so on. Lastly, document, review, and look for hardening measures or improvements to avoid similar situations in the future. One word of advice here, I would encourage everyone to develop a data incident playbook and conduct annual simulation exercises. It is not ideal to set up a response team for the first time or be doing this when you're going through an ongoing incident, as situations are fluid and fraught with unknowns. Lastly, regardless of where you choose to start, keep evolving. Embrace a culture of learning and continuous improvement. Become a lifetime learner and student. That's all for this segment of the Privacy PowerUp series. Next up will be the data collection, minimization, retention, deletion, necessity video. Thanks for watching this very first Privacy PowerUp series video from TrustArc. Make sure to check out all 10 videos in TrustArc PowerUp series.